Good evening, everyone. Thank you so much for joining in for this webinar on a Friday evening on the topic of effective claim management in construction contracts with a special focus on time bar clauses. I am Gunjan Chhabra, a dual qualified lawyer with 12 years of experience in dispute resolution with a special expertise in construction and infrastructure disputes. I am currently working with MRP Advisory as their partner. As a firm, we have firsthand seen the critical importance of managing claims effectively, especially in contracts with time bar clauses, as well as the consequence of what happens or doesn't happen in cases of failure to invoke claims effectively, which is one of the key reasons why we've organized the present session today. Today, I'm joined by a stellar panel of speakers. Our first special panelist is Mr. Arun Varma, who is a designated senior advocate of the Delhi High Court and practices law before various courts with an experience of close to 4 decades. He is an alumnus of Modern School, Barakhamba Road, has completed his BSc from Hansraj College and his LLB from Campus Law Center, Delhi University. He is also a fellow of Chartered Institute of Arbitrators, UK. Till date, Mr. Arun Varma has conducted close to 200 arbitration matters, both nationally and internationally, before various tribunals consisting of former Supreme Court and High Court judges, as well as technocrats. He has also been involved in very high-stake disputes arising out of construction of projects of national importance. Mr. Varma has earned the reputation of being a highly dependable and focused litigator. We welcome you, sir.
Thank you very much, Gunjan, for having me on this panel. Thank you so much.
We also have with us today Ms. Sandhya Prakash, who is Country Legal Manager with IKEA India Private Limited. Sandhya has done her schooling in Mysore, Karnataka, her LLB from JSS Law College, Mysore, and her LLM in Constitution and Business Laws, where she secured first rank from University of Mysore. She has a diverse experience of working in civil practice, legal compliance, due diligence, drafting, as well as negotiating contracts. She has also held teaching positions, being an assistant professor at Bangalore Institute of Legal Studies, and even worked as head of department in law. Sandhya joined IKEA in 2017 as a property lawyer and was elevated as country legal manager at IKEA. Welcome, Sandhya.
Thank you so much. Thanks, Gunjan.
So today we also have with us Mr. Amit Bansal. He is partner with Deloitte, leading the dispute and litigation advisory and antitrust services in the forensic and financial crime field. He comes with an experience of over 2 decades, having been engaged 150 times for various assignments, including commercial disputes that were under international domestic arbitrations, covering contract terminations, representation to regulatory authorities, and computation of damages, computation of claims for loss of profits, etc. Mr. Bansal is quite a regular speaker in various forums. Mr. Amit Bansal, we are so happy to have you here.
Thank you. Thank you.
Now, moving on, the moderator for today's session is Mr. Sarthak Arora. So over to you, Sarthak.
Thank you, Gunjan. Welcome to today's webinar on effective claim management in construction contracts. My name is Sarthak Arora, and I will be your moderator for the session. Our focus will be on a crucial aspect of construction contracts, that is time bar clauses. Typically, time bar clauses in contracts can make or break the ability to successfully file and resolve claims. So understanding them becomes critical. So what essentially are time bar clauses? Time bar clauses refer to the provisions of various contracts that specify a time frame for making or presenting claims, and failure to do which can lead to a waiver contracts, which are governed by FIDIC Yellow Book, which is clause 20.1. This clause in particular provides a 2-stage time bar process for submitting claims for extension of time or additional payments. First, the contractor is required to provide a notice within 28 days from the date he gets the knowledge of the said event. And second, a fully detailed claim must be submitted within 42 days. As in this clause, time bar clauses ordinarily provide that failure to raise claims within these time limits will cause a waiver of claims by the respective party. This leads us to many big questions which affect several stakeholders in the infrastructure and construction industry. During the course of this webinar, we shall be hearing on our stellar panelists who are recognized experts in these fields regarding various issues pertaining to strictness of these time bar clauses and their arbitrability. We will also discuss the purpose of time bar clauses, best practices for contractors to comply with them, and strategies to mitigate that risk. During the course of the webinar, we also encourage the audience to submit any questions which they may have. We will address these queries in the Q&A session at the end of our discussion. I once again welcome our panelists and will begin with my question for today's webinar. My first question is to you, Ms. Sandhya. Are you familiar with these kind of clauses? In your experience, what can be said about these clauses? And in contracts where you are from the employer's side, how seriously do you take the implementation of these clauses?
Yeah, thank you so much, Sarthak. Yes, certainly familiar, as the claim management is one of the key aspects in the construction contracts. To have an effective claim management in place, every employer need to have at least three important things. One is that well-drafted contract. Second is a good contract management skills. And the third is experienced engineer in place. Every market will have its own contract clauses, and mostly all the employers wish to show their dominant position and trust the contractor with one-sided clauses. This might lead to many disputes, and hence as an employer, we always go with a balanced contract, which is a FIDIC contract. As you might all be aware, FIDIC contract is a contract, construction contract with various kinds of books, which also is more neutral towards the employer and the contractor. Now, so basically, this FIDIC contract also has been agile to suit the current requirement. So FIDIC contract's first edition was in 1999. As you rightly pointed out, it is also there in 2017. LO book has been modified, and again 2011 also there is some modifications of other FIDIC contracts. So why is this modification done? Is only to have more and more learning brought into the contracts. So while we as an employer use the FIDIC contracts, this time barred clause are the ones which has to have a special focus to it. So time bar clause and the clauses that deals with claims are the ones that have been seen to be modified from time to time to suit the present day requirement and is to be made mutual by the FIDIC. Now, the major clause which has undergone a lot of change between 1999 and 2017 editions are the claim clause. Now, earlier in 1999, the claim clause was only applicable for the contractor's claim. But later, what has been done is they have included the employer's claim also into it. So they have made it more mutual. They have also brought in the timelines, and they have also brought in the nitty-gritties of that particular time bar clause, saying that in case where the contractor issues a notice of claim, then the engineer or the employer also has to revert back within a particular time. If they don't revert back and the claim is even submitted after the time barred date, then also an employer will not be able to raise the same aspect later. So here there are more and more agility brought into this kind of a contract. Now, as an employer, we would be very happy while drafting the contract, saying that, oh, we have negotiated a very good contract and we have a good time barred clause brought into it. Now, when we say time barred clause, what exactly do we do is that we say it is the contractor who has to bring a notice of claim within 28 days from the date of occurrence of that particular event, or from the date of the contract being there is a reason to believe that the contractor has got to know about that issue which arises a claim. Now, that reason to believe is something which is open for interpretation. It cannot be the same that everybody will have the same thing. It's only up to the contractor who can substantiate his claim by saying that, yes, I got to know about this matter only as of this day. Now, then the second is also that the engineer should be proactive. The engineer has to send back this notice within 14 days saying that your claim, notice of claim, is time barred already. Now, even if the engineer is very proactive and he also sends this kind of a notice rebutting the claim and saying that you have not filed it within the time limit, then also the contractor will be in a dominant position when he is in the site. What he has is that more accessibility to the site, more issues are known to the contractor, and he can also substantiate to say that, yes, I had reasons to believe that this is the day when I've got to know this particular claim. and hence I am entitled to this claim. So the employer will be at fix every time, because the employer, the retail employer, for example, like how our employer, we are the employers, we are more interested in getting into the project completion phase and getting our retail store put in place rather than going and fighting for a time barred clause. So what we actually do is we still go ahead and we bring in this importance of time barred clause. We also issue a notice of claim, or we also consider the notice of claim, rebut within 14 days saying that it is time barred if it is time barred. However, the contractor will have a right to provide his contemporary records and also the final claim up to 82 days. That is the date from the date of he being having reasons to believe that he got to know that particular claim as of that day. So this 82 days is a long time gap for the contractor to substantiate, as he will have all the documents in place. Now, as an employer, what we actually do is that we take the time barred clause seriously. We try to push the engineer to even be proactive and to state that the contractors are not entitled for such claims. But ultimately, when the contractors share their contemporary records and final claim report, we'll always go ahead and say that, yes, if you have got these kind of substantiating documents, we will get into the veracity of the claim rather than bringing the time barred clause in place, because we do not want as an employer to punish the contractor for the work he has already done just because of these technical nitty-gritties. So ultimately, as an employer, we will always test the genuineness of the claim rather than getting into the time barred clause. Thank you.
Right. Thank you, Ms. Sandhya. That was actually very insightful. The role of documents and the role of maintaining the contemporaneous records are very critical to this. Moving on to Mr. Arun Varma, sir. Sir, how do Indian courts typically interpret time-bar clauses in construction contracts vis-a-vis the Limitation Act? Can parties usually limit the time period for raising claims by using such clauses?
Thank you, Sarthak, for that question. What Sandhya has said, and as I have understood, it's a very practical way of looking at things when you are operating a contract without looking into the legality or what is going to be the outcome. For the success of a contract, this kind of cooperation and maturity, if we can see everywhere, then probably the litigation would be reduced to quite a lot of quite a lower level. But unfortunately, when it comes to brass tacks and people are at loggerheads, they want to take advantage of any clause in the contract and then go to a court or a tribunal. However, as you have rightly asked the question, Sarthak, when we are talking about a time bar clause, obviously we are talking about the relationship of the Limitation Act. And my take on this is purely from a legal point of view. When a dispute comes either before an arbitral tribunal or a court of law, then what the Limitation Act has to say as far as raising of disputes and considering the disputes for adjudication is concerned. As we all know that the Limitation Act provides a limitation for filing or taking out legal actions against different kind of disputes before courts and arbitrations. There has always been this conflict between the time bar clauses which parties put into a contract, where they say that if a dispute arises and you don't raise or don't give a notice in a certain period of time, you will lose your right. Or they say that if you don't take out your legal proceedings within a particular period of time, then you will not be able to agitate it before a court of law or arbitration. So the Indian Contract Act itself provides for a situation like this, which is Section 28. And what is interesting to note about Section 28 is that what exactly Sandhya said, that the disparity of bargaining power can be misutilized in a situation like this. In 1997, this section was amended to actually take care of this situation where this disparity or unevenness or inequality of bargaining power between the contracting parties could not be misused. So what has ultimately happened is that prior to the amendment in 1997, what Section 28 did was to declare those clauses in a contract which would take away a remedy. Remedy means that you have a right, it has been flouted by somebody, you want to take out legal action in any forum, wherever it is, And then if the remedy is extinguished or curtailed, those kind of clauses were considered as void under that section. But what was strange was till 1997, extinguishment of right that a party might have, if a clause takes away that. For example, in a contract that Sandhya was referring, it says if you don't give a notice within 30 days period of the happening of something, you lose your right to claim damages or things like that. Till 1997, the law was that yes, a clause can take away that right, but and it will not be declared as void. That would be a binding clause between the parties. So this kind of an anomaly where the larger difficulty was not being addressed and the remedy only was taken care of, the amendment in 1997 took care of that. And as far as the current law situation is concerned, any clause in a contract which is contrary to any kind of limitation which either affects a right of a party to a contract, which is otherwise provided under the law, or a remedy that can be taken out, which is provided by the Limitation Act, that clause would be void and will not be enforceable either by an arbitral tribunal or a court of law. So that is the current legal situation as far as dealing with the implementation of such clauses if there is a dispute between the parties.
Thank you for that perspective, sir. My next question is directed to Ms. Gunjan. Could you elaborate a bit more on these time-bar clauses and what concerns arise, especially vis-a-vis the arbitrability of such claims when such clauses are concerned?
Okay, thank you so much for your question, Sarthak. Very interesting question. So, see, essentially, when we talk about arbitrability in contracts, which usually have time bar clauses, it boils down to whether or not the claim has been notified, like what Sandhya and Arun Varma sir have explained. When these claims are notified in terms of the contract within the timelines, they are termed as notified claims. So you will see in a lot of construction contracts, especially some railway contracts and CPWD contracts, that the arbitrability of the claims will be linked to whether the claim has been notified or not. So, these kind of clauses essentially will provide, number one, that only those claims which have been notified by the contractor included in the final bill can be referred to arbitration. Number two, usually the general manager or some official of the employer will have the power to decide whether a particular claim is a notified claim or not. And number three, once the general manager or the official of the employer decides that a particular claim is a notified claim, that is the precondition for referring this claim to an arbitration. Okay, so over here, the language of the dispute resolution clause becomes very relevant and it links the claim being notified to the arbitrability. But there will also be another type of clause where you will simply find that the notified claim clause simply provides that if your claim is not notified, then you will have waived that claim. But when you look at the dispute resolution clause, it is not going to be linked to the notified claims clause. It's going to be very widely worded, saying that all disputes arising out of the contract or meaning of the of the contract can be referred to arbitration. So in such cases where the clause is very widely worded, at least we know that, okay, even if I have not notified my claim, the arbitrator at least has jurisdiction to decide whether this claim will ultimately be granted or not, keeping in mind your other legalities involved. So, the arbitrability then doesn't become a question anymore. But in the type of the contracts which I did mention before, which is your railways and your CPWD contracts, it will have a very strong impact on the arbitrability of claims because the arbitration clause is going to be linked to the claim being notified. So I think in simple words to answer your question, the arbitrability in the context of time bar clauses will depend on the language of the dispute resolution clause and the connectivity of the dispute resolution clause to your notified or time bar clause. So, yes.
Thank you, Gunjan. Thank you for that perspective. My next question is going forward to Mr. Bansal. Mr. Bansal, what would you say are some of the best practices that can be followed by contractors to ensure that contemporaneous documents are maintained, especially when these time-bar clauses are involved in contracts?
That's a very wide question in terms of, what kind of contemporaneous records. Where the contemporaneous records will actually depend upon what is the nature and matter which the issue at hand. To give you an example, it could be a force majeure issue, it could be a change in law situation, it could be a scope creep situation, or it could be a variation aspect. Now, each one of this, the contemporaneous records may differ. Now, how does a contractor really take care and prepare himself for any such situations? I think the first and important thing is to identify at the beginning of the contract itself, when the contract gets signed and the executions start, identify all of those clauses where there are, time bar issues, and identify those situations. If such and such event happens, then there needs to be a communication which needs to go from our side. And somebody, let's say a contract management team, different organizations may have different structures. There could be a contract management team who could look at something like that. Now, and that is where what kind of contract management practices are there, and what kind of a contract management structure is there, that becomes important. Second part of the second part of this is in terms of, typically I have seen in every situation when there is a matter under arbitration, whether time bar or otherwise, the level of documentation is very, very poor. One is the communication part. The active contract management can take care of the communication bit. The second part, which is important, is with respect to what was the original plan. Original plan, both in terms of project cost and project schedule. We need to have a fully cost loaded baseline schedule, which is approved by the other side. And now, especially in government kind of context, there are times when the approvals will not come. At least that should have been submitted. So that tomorrow, even if the other side raises an issue that we never approved it, but if you have submitted it and the next set of invoices, the billing, invoicing and clearance of those invoices is happening basis all of that, then it establishes an history, and from a evidentiary perspective, the case becomes stronger. The third aspect is, how are you monitoring your progress of the project? And that goes down to the project management practices. So that is where you need to have very strong project management practices, where you are actually having daily progress reports, weekly progress reports, and monthly progress reports, and any kind of changes which are happening, whether through variations, any kind of events, they need to find a mention on all of them. The moment that happens, and in most of the large contracts we have seen, the employer does warrant all of these daily progress reports or monthly progress reports or weekly progress reports to be submitted. So in an absence of, let us assume the communication has not got, you have not notified within the first 28 days. But if a weekly progress report or a monthly progress report has been submitted, it can actually, one can argue that, see, this has been notified. It may not be in the form and shape it was warranted.
Right, sir. Thank you, Mr. Bansal. Returning to you, Ms. Sandhya, can you share any insights or instances where the enforcement or neglect of these time bar clauses had a significant impact on a project or a dispute resolution in your experience?
Thank you, Sarthak. Yes, of course. Significant project impact as well as the dispute resolution will happen. But then in our case, not specifically in our case where I am working currently, but I can share some instances which have come across till now. Because like Mr. Amit Varma mentioned, in large projects, contract management is an issue. Second is having an experienced engineer will be is common in large projects. However, the engineer will also do their part, and then again, the employer will also have to review those reports, which Mr. Amit Varma has mentioned, right? So there are a lot of times what happens is that the employer will leave it completely to the engineer, and they will not even review it. So then engineer will be waiting for the employer to revert back. At that point in time, what happens is that the time barred clause will be barred even for the employer to go back and even claim for it. So at that point in time, we can call it as a neglect. But when we do that kind of a neglect, then it is that we have only neglected. In case where we go ahead and enforce such kind of time barred clauses, the contractor will be very smart, and the contractor always shows his dominant position, slows down entire project progress, brings down their labor force a little by little, and then finally it ends up in a mess and the project completion will not happen on time. Then again, the contractor will have a right to ask for EOT later, that extension of time later. So this is how where there will be an issue. I can give one instance which I have come across, that initially, the contractor did not even he did not even read his contract properly because he was more interested in getting more and more work by way of variation. After all the variation has been received, once the contract came to a closure, that is, the project came to a closure, at that point in time, the contractor started raising invoices. And that invoices was not an approved invoice. When the employer asks, why is it and where is the approval for this? The contractor says the engineer had approved it. But as on that particular day, the engineer had left the site. And there is nothing which employer has to show that, yeah, this was approved, not approved. When the employer was deliberating as to whether we really have to pay, there is substantial claim, no claim, etc., then the contractor went under MSME route and took it saying that the invoice has been raised, but there is nothing which has been paid. So these things come ultimately, in my experience, being part of the employer's team, I feel employer will always be under a double-edged sword all the time. So that is the reason why I think we need to choose the battle right as an employer all the time as well. Thank you.
That's a very valuable example, Ms. Sandhya. Mr. Bansal, in light of such instances, what risk management strategies would you recommend to construction companies to mitigate the risk associated with these time bar clauses?
I'll pick on what Sandhya said. Invariably what I have seen is, the legal teams and the contract teams will negotiate a contract for donkey's years, but they will never go back to the contract when it comes to the actual execution period. Now, I think one of the best practices, the moment the contract is signed, sit down and identify the risk areas within the contract itself. Identify clauses which permit you for, let's say, variation orders, escalations, delays, EOTs, and visualize all of those situations. Bases the terms of the contract. And your contract management team then needs to monitor those things very, very closely. So that, when such and such event happens, then one is not thinking in terms of whether it falls under this or not. I'm sure if there may still be such an event, COVID kind of a thing happened, no one would have put a COVID in that list. But at least 90% of the regular routine events would be listed in that. So then, you are not getting into a process, internal discussion, brainstorming, taking approvals, and your time to notify the employer is gone. So it starts with, putting that long list of events, training your contract management team, training your project execution team. Well, contract management team cannot work in isolation. Yesterday only I was in a meeting with one of the EPC companies. And he says, my contract management team, my claims team, and my legal team, they don't talk to each other. And the fourth team is the business team, the project team. None of them, they talk to each other, and everyone is working in isolation. The moment a situation happens, they pass on the baby to the Okay, this is contract responsibility. This is legal responsibility. It cannot work like that.
Right, sir. Right. Completely.
So the clear handover, a division of responsibility internally, the role identification of the situations, the risk management starts from there.
Right. Right. Thank you, Mr. Bansal. That was very insightful. My next question is to Mr. Varma. So, how the parties to a dispute should interpret these clauses, and are there any specific case laws or precedents which deals with this issue?
See, as I said in my opening remark, the legal position is very clear as far as the enforceability of such like clauses before a court of law or an arbitral tribunal is concerned. But before I answer that question, I think just a small comment on what has come from Amit and Sandhya. Uh, they are the people who actually have to carry on with their contracts. They have to get work executed. They have to execute works. And Amit, of course, has to advise people who are dealing with situations like this. Uh, I fully agree that record keeping in terms of contemporaneous situations which may have effect on your claims later on is the most important thing for any litigation. If there is no contemporaneous record keeping, then everybody is at sea and you don't know what is going to happen. Uh, so when a situation arises, like you said, a force majeure condition like COVID or any other thing, obviously the effects of that have to be recorded. They should be available for somebody later on to deal with a situation like this. But if we are only talking about the legal efficacy of a contract or a provision in a contract which curtails your right to agitate a claim like this. Now, I'm taking a hypothetical situation where what was said by Gunjan, that there should be a notified claim at the right point of time. Whenever there is a cause, you notify the other side saying that this is the situation and we are the sufferers or whatever the situation is, and we'll be raising a claim or this is our claim. Earlier, of course, the examples which he cited were very much there that if you don't notify a claim, you lose your right. And once it is a non-notified claim, the tribunals would reject the claim only on that basis, the tribunals or the courts. But as I said, with this amendment that has come to the section 28, let us assume that there is a contract which is going on for 2-3 years, and there is a situation where a contractor has a claim against the owner, and somehow he does not notify it even in the vaguest manner, in the sense that not even giving a notice or something which can be called as a semblance of a notice. Not everything is absent. He may have practical difficulties while proving his case before an arbitral tribunal because of lack of record, but his right to agitate that claim or his right to get an adjudication on merits. I'm not talking of evidence for the moment. It may not have the right kind of evidence, but that right does not go away. So earlier, what used to be considered as an absence of notified claim as a death knell for your claim, that situation is gone. So when you have to raise a claim, you can raise a claim as long as you are able to satisfy the adjudicating body, court or an arbitral tribunal that you really have a claim and this is the substantiation of the claim. So we'll have to deal with practical aspects which are separate from the legal aspects when it comes to adjudication before a court of law or arbitral tribunal. That right can never be extinguished now. Of course, it could be otherwise beyond the limitation when you are agitating your right, the Limitation Act. There could be accepted matters agreed between the parties which would take away those issues from outside the scope of arbitration. But then the right to sue or the right itself remains unaffected by any such time limiting clauses.
Right, sir. Thank you. Thank you, sir. My last question is to Ms. Gunjan. We have heard a lot about time bar clauses in the common law perspective, but in the context of civil law jurisdictions, how do these time bar clauses differ from those in common law jurisdictions? Are there any unique challenges or benefits that you have encountered?
Right. Sarthak, very interesting question. So just before I come to your question, I think, Sandhya and Mr. Amit Bansal and Arun Varma, sir, all three of you have raised such interesting points. So, as far as the coordination between the contract teams and the lawyers, this is one of the purposes of this webinar, so that there's better coordination between the practicality and the legality of claim management. And, there's a wholesome perspective to the whole thing. And Arun Varma sir's comments regarding accepted matters, that is exactly what I mean when I talk about arbitrability. So if suppose your notified claim and the subject matter is an accepted matter, so then your claim gets excluded from arbitrability. You can, of course, raise your claims by other methods, but then arbitrability is something that will come into question. So very, very interesting discussion, very stimulating. So coming back to Sarthak's question, Sarthak, very interestingly, because this entire discussion right now has been revolving around common law. So interestingly, what in civil law now? So I would say from a civil law perspective, the major difference would be precedents, right? Common law jurisdictions, you're going to find case laws and the other precedents which are going to support you. But civil law is strictly going to be based on codified laws and civil codes and very specific statutes. And these time periods are usually going to be fixed, and they're going to be considered much more rigid and uniform in comparison to common law jurisdictions. And see, ultimately what it does is, because you also asked about the advantages and disadvantages, what can be seen as an advantage in civil law jurisdiction is that there are going to be a better predictability of the outcome of a dispute due to these codes. Right. But on the other side of the coin would be that parties would ultimately have less flexibility in party autonomy. So, you're not going to be able to modify or waive these statutory prescription periods. So there's going to be less party autonomy in these, and rules will be more rigid. And, just to bring in an example of civil codes applying to this dispute, we can refer to UAE Civil Code. In cases where time bar clause are present, you will have various provisions which will go in favor of interpreting that time bar clause very specifically. For instance, you would have, Article 243 or 265 of the UAE Civil Code, which provides that parties cannot deviate from the express language of the contract. But then you will also have provisions in, say, the UAE Civil Code, which would be concomitant to Article 246 and 106, which are overarching provisions of good faith. So in case you can prove that the strict interpretation of the time bar clause will ultimately seriously prejudice the contractor and prejudice the good faith obligation, you can actually avoid this clause completely. So, you'll come across examples where the employer was essentially very aware of the contractor's claims, but it was simply arguing waiver to the claim not being in the proper form, which, Sandhya also brought about earlier in the discussion. So in these type of cases, then you will ignore the time bar and you will go with the good faith obligations and not strictly interpret the contract then. Similarly, the time bar will also become inapplicable where the employer himself would have caused a delay or breach or some other breach. So then again, your good faith comes in and your particular time bar clause will become inapplicable. Delay in notifying the claim. So that's the kind of delay that I'm talking about. Then, of course, you will have a lot of other provisions in civil codes like unjust enrichment and all of which will come into play and make such a time bar clause inapplicable, giving it sort of a very lenient interpretation. So this is something that happens in civil law quite a bit. So yeah, that's about it.
Right. That was actually very interesting that the principles of good faith and unjust enrichment plays a vital role in determining these kind of situations.
Just one small comment before we move forward. You had started with a reference to clause 20.1 of the FIDIC Yellow Book. And of course, because these kind of contracts are adopted very widely all over the world, including in many contracting parties or many projects in India. But as far as this FIDIC contract, it's a standard form contract. It's a very generalized kind of a contract which can be modified suiting the local conditions. But even if you don't modify this and you adopt it as it is, even then the local law, wherever this jurisdiction is, for example, a FIDIC contract being adopted in India, the terms and conditions will still have to be understood as per our Indian legal system, which could be totally different from the UAE or any other jurisdiction. So adoption of a standard form contract would not make a difference as far as the applicability of the law is concerned. That is a very important factor which everybody should keep in mind, that just because it is FIDIC, it will have a different meaning in India. It's not that. It has to be as per the Indian law.
Can I also add on to what Mr. Arun Varma said on this? It's also, yes, I agree with what you're saying, Mr. Arun Varma, but it also, what we actually do is in the particular conditions, there is a possibility of making it suitable to our local legal requirements as well. One point which I also missed is that there is a DAAB provision which has been brought in the FIDIC right now, where the Dispute Avoidance and Adjudication Board can be formed even at the beginning of the contract itself. So in that case, what happens is that the DAAB will visit the site every month or once in 15 days. They will already monitor the entire progress. So before getting into the arbitration is where this DAAB is the resolution mechanism which can be used. So this also helps us to have this time-barred clause sorted even before getting into an arbitration phase. Thank you.
Just one, I'm so sorry. This DAB or DRB has been in vogue in India for like forever. FIDIC maybe, and actually in the earlier form of the FIDIC contracts also, a DRB or a DAB has always been there by a different name, of course, DRB and DAB.
Sure.
Right, sir. Thank you all. Thank you to all our panelists for those insightful responses. Now we have time for questions from the audience. We have actually received a lot of questions, but due to time constraints, we can only address a few. So let's start with a question for Mr. Arun Varma, sir. So, any seminal case laws indicating the Settled State of Limitation Act and the time bar clauses? Any case laws pertaining to that?
So when we are dealing with case laws, of course, there are a whole bunch of judgments. But if you are looking at it, then one should be very careful about not to refer to judgments which relate to the pre-amended era, because that will cause a lot of confusion. And there was a lot of confusion which was going on till it was sorted out by the Supreme Court in it was somewhere in September 2016 that a judgment was given by the Supreme Court. This is Union of India versus IndusInd Bank. Now, just imagine the amendment happened in 1997, but this judgment came in 2016. And till that time, there was a huge controversy or a huge difference of opinion between courts, whether the amendment is prospective or retrospective in nature, what kind of contracts, what date of contracts this would become applicable to, which was then decided by the Supreme Court that because this being a substantive change in law, it would be applicable only to contracts which are executed after the date of the amendment, which is 1987. Now, if you are looking at the current state of affairs, there are a number of judgments, and I think one of the easiest to read judgment, which has all the earlier case law fully describing this change in law and the applicability, is given by the Delhi High Court in a matter of Municipal Corporation of Delhi versus Natraj Construction Company. This decision was given on 22nd of March 2023 in FAO 432 of 2010. Must have been reported somewhere, I don't have the citation. But in this judgment, the entire background and all the earlier judgments have been discussed. And if you read this judgment, you'll get a fair idea, actually better than a fair idea, about how the law is developed and what is the applicable law as far as time bar clauses are concerned.
Right, sir. Right. Thank you. Moving on to our next question. The next question is to Ms. Sandhya. Could you please explain the purpose of incorporating time bar clauses in the contract? Is it only to afford an opportunity to the other party to mitigate the effects?
Yeah, good question. So basically, the time bar clause have been negotiated for a purpose. So the employer wants to have that kind of a time bar clause implemented, enforced at each point in time. But as I mentioned, it's hard to be enforced, even though we bring in that time bar clause. It is a kind of a negotiation route, which we can call it as. We bring in a time bar clause. If the contract management skills is good, it continues and it gives us benefits. If that is not there, then at least we have a kind of coming to a mutual path between the contractor and the employer. So this is not just to keep it, but it is also for a purpose. And then we take it seriously as well as an employer all the time. Thank you.
So I'll just like to add to what Sandhya said, is also like from an employer perspective, what we have seen is they will like to have more certainty on the cost, completion, all of those aspects. So having those certain time limits ensures discipline at the contractor level. So one is the discipline issue. The second is also in terms of, the claim should not be an afterthought. That, hey, I have somehow mismanaged project. I have gone overboard in terms of cost. Now let me figure out how I can make claims. Now, it is basically from those two perspectives, I would say that, that's basis my experience with my clients. What I can understand, that's largely the reason. While legally it may be very difficult to enforce.
Right, sir. Thank you. Moving on to our next question, Ms. Gunjan, will the time-barred claims also hamper my likelihood of succeeding in a suit for damages? Can the arbitration clause in this case would stand in my way?
Okay, so Sarthak, this is again stemming from the discussion which we've just had and which Mr. Arun Varma was also mentioning. Now, if suppose there is a notified claim clause and, it's arbitrable nevertheless. So even if whether it's a notified claim or not, but the contract provides all disputes are going to be referred to arbitration, then of course this clause will come in the way of filing a suit, because if there's an arbitration clause, ultimately your matter is going to be referred to arbitration, and then you can take up this notified claim issue there. But the other scenario would be where, say, the claim not being notified and the decision as to the notification of the claim would be an accepted matter. If it's an accepted matter, then of course your arbitrability will come in and you cannot raise it in arbitration. In those cases, for those particular claims which are not notified claims, you can go in a suit for damages because it's going to be beyond the scope of arbitration. So you will go in a suit, not necessarily for damages, but for claims or compensation. And, this is not to speak about the ultimate success of the claim which may come about. But of course, you can go for a suit where your claim is not arbitrable. So, yeah, that's it.
Right. Yeah. Thank you. Mr. Bansal, my next question is to you. That how to deal with concurrent delays.
How to?
How to deal with concurrent delays.
That's a subject in itself. Difficult we can have
you'll have to have a full day seminar on this.
Yeah, right.
not a 1 hour webinar.
And apportionment and everything. So I think this is a very good question.
So, yeah, we can move to the next question then. My next question is to Ms. Sandhya. Ms. Sandhya, could you please elaborate on the difference between the two FIDIC versions? This question has been put forward. Yeah.
Yes, thank you. So basically, again, like Mr. Bansal said, this is also a full day aspect, but I can give you a brief. The two FIDIC versions are the ones which are modified editions. So like I said earlier, the modified editions are something where to suit the present day requirement and to make it more mutual. This, I would say, is because of the learnings which the FIDIC would have got for all these years. So basically, because of that, to make it more agile, this new editions will be brought in. And second is also that, like Mr. Arun Varma was also mentioning, that there was DRB earlier. So DRB is a dispute resolution board which was brought in earlier. Later, it was realized that the resolution can come only when there is a dispute. So that is the reason why they made it more agile and brought in avoidance and adjudication board. So this is something, these are the things which have been modified between the earlier editions and the current editions.
Yeah. Right. Thank you. My next question is to Ms. Gunjan. How does one overcome the threshold of arbitrability of a claim in a Section 11 Yeah, when the general manager determines whether a claim is notified and the arbitration clause is narrow. Yeah, it states that only the notified claims are subject to arbitration.
Thanks,
Yeah.
Arthur. Okay, I think this is coming from IOCL contracts, if I'm not wrong. But so, essentially what happens is that there was an amendment which happened in Section 11 in actually the whole Arbitration Act in 2015, post which the courts only look at the prima facie existence of the arbitration clause, whether or not it exists. And there is a complete line of judgments also, which used to say that there is accord and satisfaction if the general manager has held that the claim is not notified. But there is also one recent judgment, if I'm not wrong, which deals with this issue and says that let the arbitrator decide whether the claim is notified or not. So essentially, they are passing the buck now to the arbitrator, and the arbitrator gets jurisdiction under Section 16 to decide whether or not the claim can be arbitrable or not. So the courts have stopped deciding that. There was a judgment. There was a 2022 judgment, if I'm not wrong. So yes,
if I'm not mistaken, you are referring to the SBI life insurance judgment by the Supreme Court, where the only issue now left for a Section 11 court is to see whether there is an arbitration agreement or not.
Yes, so yes, absolutely. That is the one that I'm referring to. And I believe specifically on these general manager, not declaring the claim not to be a notified claim, there's a 2022 judgment. I think it's NCC, if I'm not wrong. That judgment specifically deals with this issue that now it is the arbitral tribunal who will decide whether the claim is arbitrable or not also. So, your threshold problem is solved. But the ultimate problem might not be solved, but the threshold problem is solved.
Yes. Moving on to our last question. My last question is addressed to Mr. Varma. Sir, do you think these time-barred clauses are against the principle of natural justice in an Indian scenario?
See, my understanding of the principles of natural justice has got nothing to do with a commercial contract or a private dispute between the parties. There's something to do with the administrative law. But I personally, I think there is a very, very well-established principle of jurisprudence which says that you cannot contract against the statute. Whatever the statute provides, unless the statute permits you to contract outside of it, you cannot. So if we go by that principle, then any kind of contract between or clause between the parties which reduces or impacts what is provided by the statute would not be enforceable. Of course, there are exceptions to this, which can be looked into from different statutes point of view. But that is the age-old principle of jurisprudence which has been followed in this situation. And secondly, the general trends of the court is, or tribunals should be, that people should get decisions on merits and not technicalities. Once there is a dispute between an adjudicating body, if legally permissible, and the law should bend in favor of a decision on merits rather than technicalities, because ultimately there could be oversights, there could be even, I'll go to the extent of saying negligence, but that should not take away the right if the law provides such a right to one of the parties. So that is, I believe, the basic underlying principle which needs to be followed.
Right, sir. Right. And yeah, that's all for the question and answers round. Certainly, we've had a range of interesting discussion today, and it's clear that this topic of time-bar clause is both complex and critical in construction contracts. So as we approach to the conclusion of our webinar, I'd like to extend our heartfelt thanks to the esteemed panelists for sharing their profound insights. A big thank you to our audience for their active participation. If you have any queries or suggestions, you can share with us on our email. Once again, thank you all for joining us today. Wishing everyone a great evening ahead.
Thank you very much for having us here. Thank you.
Yep. Thank you. Thank you, everyone. Bye-bye.